Dear friends, this is the part two of this discussion on the SLP before Honble Supreme Court that likely to be coming up for hearing next 7th of October. Now, here the SLP for the students of law, for the lawyers, there are two parts in which we are going to publish this article. One is how are you preparing the SLP? And secondly, how should you prepare without any defects so that your case can be without defects, and means then they will give a diary number, then they will check for defectives and thereafter number it. It's very systematic. Honorable Supreme Court is very good. All online only. You don't need to do anything. So you need to learn as advocate on record. So first we'll talk about the way in which you are going to appear as a lawyer before the Honorable Supreme Court. And this is the Supreme Court thing. And we'll move with that. Right. So this is declaration. I'll straight away come to the subject matter. And one is a fast explanation, another is for students, very slow, step by step. I'm going to go in the third video. How to prepare it, easily you can see. I've done a lot of work on this to explore and then teach to the students law, all the people to get a clear picture. And these are all the documents which required, numbered there. Right, this is the synopsis. I must tell you that how a synopsis to be prepared. Honorable Justice Abhay Oak's lectures you can see for advocates on record. What Lordship said is that generally in a day, miscellaneous days only these admission cases are taken either Monday or Friday in that time. So he said, frankly, we'll just come up reading and only we read the synopsis. And he said, synopsis, you should not write too much. You should be to the point because it is a judicial review. In this, my case, I am challenging the order of Honorable Division Bench of Madras High Court. Therefore, the order passed. What is the infirmity in the order first? So, judicial review is testing the veracity against the touchstone of law. But the procedure followed by the lower court, that is in this case division bench. So what is the procedure? Right. Secondly, it should be very crisp and you should tag with the documents. You should not allow the judges to go on referred to. So if you see my case, the first question is I have to convince their lordships that 1 lakh fine is unreasonable. That means I'm a genuine party. That is very important. I have to explain that I'm concerned about the nation. I'm concerned about the cause that I'm agitating before the court. Then the court will be convinced. You understand? So what is that the division bench took a stand for imposing fine, and then what is the infirmity and all that. So this is, you see, very carefully you write, highly polite and all. Now with the artificial intelligence coming in, though it is not per se that easy, but you need to keep discussing and then evaluate. The present specially petition is being filed against the final order dated 9/9/25. That's called the impugned order and the challenge, passed by the Honorable Division Bench of Honorable Madras High Court in writ petition 34/108. And WMP interim stay we asked for. The writ petition had sought directions to the first respondent, the Election Commission of India, on issues concerning its transparent and independent functioning. Issues concerning transparent. That's the main issue. Independency. And that is the 324 article. So as to reassure the common man that common citizen, that is democratic rights to vote remain safe and secure. So this is annexures P2. 49 to 68 page you can find. Basically, it will be what I filed before the division bench. Writ petition, interim petition, and affidavit will be there. So they will check that up and okay. Now, next is survey. What is that petitioner? This is the main case because the fine is there. So the petitioner is a practicing chartered accountant and a renowned professor for CA students with 4 decades of dedicated professional service. He has trained thousands of socially and economically backward students on a pro bono basis, many of whom have gone on to qualify as chartered accountants and are presently serving as directors of the top company executives and top executives of companies worldwide. The petitioner authored books on strategic finance and strategic cost management and the quote crafting techniques to law students. I'm doing a lot of work on this artificial intelligence, my friends, to how best you can use it to come out very successfully. Very earlier, even for writing this petition, we drafted it in one day. And how artificial, we use this Perplexity, ChatGPT, and Gemini. And then a lot of brainstorming will be done. Then the machine per se will not give you anything, but you have to ask. Otherwise, it will be dangerous. So therefore, that I will teach you in my next thing, how I applied it. So this is what is the main, because 1 lakh is the fine which we want to get out. And then the petitioner has filed several public interest litigation and his work has been consistently appreciated by the successive Honorable Chief Justice of the Madras High Court and by learned judges who now adorn the bench of this Honorable Court. Justice M.M. Sundaresh sir is there and R. Mahadevan sir is there. And in R. Mahadevan, Justice Sundaresh sir sat on that educational bill and R. Mahadevan sir sit again in the insolvency and bankruptcy court reforms. And that was a very against some judges who are corrupt. And R. Mahadevan sir, Justice, no. Both of them used to say he comes well prepared and we are convinced. Let them convince. So the petitioner, this is very important for me. The petitioner respectfully submits at a recent book conference function. I spoke on the justice dispensation as depicted in Valmiki because it was a book releasing function. Justice Sumudresh sir came. First, I spoke on the Dharma, concept of Dharma, taking the Vibhishan and Kumbhakarna, how the Dharma changes from time to time and all. Then the Lordships, after me, he spoke. And he is extemporary knowledge on Kambrama. And, I went prepared. He came unprepared. He never knew I will be speaking this. Then he extempore spoke on the same concept. And Lordships have said, that time Lordship was the judge of Madras High Court. Then he said, I find Venkat Kumar comes so well prepared. I in fact learn. He is a very good judge. He is the kindest of the judges. So he may be very knowledgeable, but he was kind enough to tell the audience that I really gain a lot of knowledge whenever I meet him like that. So this will be explained, P1 40. That is the first step. Judges will see and come. So let's go to P40. What is the documents I have enclosed for this? We worked on a lot of research, and we'll show you how. These are all what we filed before Honorable Division Bench of Madras High Court. You cannot bring anything new. Whatever is already there only, they will take up. Of course, you can have subsequent events, but then there's a certificate you have to say. This judgment and all, this is the appendix, it is called. In that appendix, you have to talk about Article 324, new election bills. Suddenly judges will ask, what is this and all. So you have to be ready with all the data and grounds. You are perfectly prepared. So this is what I was a professor. To establish that I was professor with Honorable Excellency Abdul Kalam. It's a great prestige in the Teachers' Day celebration, Rashtrapati Bhavan. I must remember here, Abdul Kalam ji was coming. Oh, I meet all the top people. Then I said, Yajnanam Japa Yajnosmi Stavaranam Himalayam. Abdul Kalamanam, great personality now. Oh my God, wonderful, he said. That is Lord Vishnu says, he is always in the best of the persons, lion and animals, Himalayas, mountains in the, and Garuda in birds. Yajnam is most, everything in number one, Lord Vishnu is there. Then he said, oh yes, come on, I'll give this jalebi, let's eat. What a beautiful bird, he said. So then this is where we had a discussion. White is the Justice Sundaresh sir, and last is myself and the court and all. I spoke on that. Lordship also spoke on that. To establish that we are not wanton delegates, this is a legal education reforms in BCI. BCI I filed like CA, Justice Kaul and Satyanarayana, but of course this was heard for too long. Three Chief Justices changed this petition hearing. And first it was admitted when R.K. Agarwal sir was there. Thereafter, Agnihotri was there. Then Justice Kaul is there. Then the second judges were Sundaresh sir was there, Satyanarayanan was there. And this was allowed. So, this is the all order. Direct suggestions containing the petition may be examined by the Bar Council of India. Then only AIM, BM exams and all that has come. This is the thing. So now this is first convinced. Understand. Now we'll go back to the order. And in the order, just the judges division bench, while dismissing this petition, they passed an order. And so this is the impugned order under challenge. So this is what the order passed is. So in this order, this was what I asked was this: issue a writ of mandamus directing respondent 1 to clarify its position regarding the allegations raised by the leader of the opposition in his PowerPoint presentation dated 7th August. Now, that was very convincing, shocked the nation. He is leader of the opposition, and further corroborated by Honorable Union Anurag Thakur during his press statement on 13th August. So he also said there is the election commission is not doing concern large scale voter list manipulation. 18th Lok Sabha. Both of them said means entire parliament is telling that the elections are not being conducted transparently. And therefore I asked him to direct first responder produce before this honorable court and make available in public relevant electoral data for all constituents mentioned readable format. This is the main thing. Because I'm challenging that they took defense under Kamalnath. So we're trying to say that Kamalnath is not applicable to this. And if you Kamalnath sir, that the judgment is favorable to me. Together with the detailed status report of all actions, so many people have filed complaints. And what actions are you taking? And whether audits are being conducted. That's all I asked. That will enhance the transparency. No, this thing. But then what they have said, you see, para 2. Because the Honorable Chief Justice didn't hear the matter. He said, I will impose cost, that's all. Having regard to the nature of sweeping directions or sort, I never asked any sweeping directions. If he may show so, completely misconceived. First of all, he is not agreeing that it's a public interest matter. That is Indian democracy issue of public of millions. Lordships felt this not at all important. The petition lacks concrete material and only refers to allegations, counter allegations. But is the prayer said, a lot of research was done. Here actually what research you can do? It's a clear-cut matter. We are not saying EVMs are not functioning properly and all. As a common man, ordinary man, they want assurance without there being independent research. Independent research actually doesn't apply to this. It seeks this court to make roving inquiry with represent. Everything is available with the, that's what ECA is telling. We all have, but we will not give you. We know everything. What you're saying is not correct. That's what they say. That is, I'm saying I gave you gold of 100 tons. This is the public money. You please, somebody say it's stolen. You have to say that, no, it's not stolen. It's in the bank. That's all. No such direction clarified its position to come. And that's writ petition misconduct accordingly dismissed with quantified at online. For what? And so absolutely there is nothing. Later only, this was not open court, they have not ordered, but they have finally, that one is removed. That is seeking cheap publicity. Every media were standing. We have not expressed any opinion merits and leave it to the considered upon and all. There is a conflict between what they're saying the first and what they're saying now. They expressed opinion. You have not done any research. You have just come based on the allegations. And therefore, it is not maintainable. So again, it's a contradictory, these things. It order shall not come in the way of election commission taking own decision. Issues sought to be already taken decision. That's what the election commission is saying. We have taken decision because Supreme Court has said not to give, I am not giving. So now this has to be addressed in the case. When we go to the, they come prepared. Supreme Court, everybody reads, judges are ready. You don't need to read much and show off your knowledge. 1 or 2 minutes, the case will be decided. So this is my, there are 3 things will come in. One is synopsis. We are still working on that. Synopsis 2, we have explained. And you see, you always have to have that references. Now research. That second question, they say research is not done. The writ petition was filed along with comprehensive material, including 20 video conference links containing discussion and evidence. Summarized research articles on functioning of Election Commission post 2019. Extracts from opinions of retired chief election commissioners, debates on the Constituent Assembly, and landmark judgments of this Honorable Court, including latest judgments, interim orders in the Bihar matter. A consolidated appraisal of the issues incorporating expert opinions, both support and critical of the present system, highlighting the urgent need for reforms to restore public confidence. Proceedings before this Honorable Chief Justice bench. When the matter was taken up, the Honorable Chief Justice was informed that this was a pill seeking writ of mandamus, directing the Election Commission to ensure transparency in line with the objectives of Article 324 of the Constitution, which safeguards the fundamental rights of voters and basic feature of which is the basic feature of the Constitution. Honorable Chief Justice, however, observed first beginning itself is said, you withdraw or ready for cost. Within minutes, without granting the petition an opportunity of being heard, writ petition was dismissed in the open court. Findings, grounds. Now we have to find before the Supreme Court. Challenge. The petitioner is aggrieved by the arbitrary and disproportionate imposition of cause and the refusal to consider the substantive issues raised in the writ petition, despite the detailed research and evidence placed on record. Accordingly, the petitioner respectfully prays that this Honorable Court may be pleased to set aside and allow the prayer made in the writ petition, since the matter concerns the basic feature of our Constitution and affects the democratic rights of more than 1 billion citizens of India. Then the events you have to write. And this is a last one. This is a very, very strong case for this, though this is a subsequent event. because Honorable Leader of Opposition Rahul Gandhi made another convincing presentation about some top officials in ECI indulging in deletion of voters in a scandalous manner, which is also confirmed by the admission of CC about the FIR. See, FIR has been filed by CC. So there is a fact established that there is attempts were being made to delete this 6,000. Now, why you not given for 18 months? The court cannot now dismiss or anything. So therefore, the guardian angel of our and protector of our constitution. So I am very confident that the case will stand because the whole nation is worried about it. And even I lose it 1 lakh for nation, we have to die for nation. So, and now this is the order over, which we have explained. So now the next will be what is the question of law? Supreme Court doesn't hear because once you with the division bench, it gets over. So this is the question of law. The petitioner respectfully submits that the following substantial question of law rise for consideration by this Honorable Apex Court. Whether the summary dismissal of a constitutionally significant public interest litigation without examining the material placed on record or offering a reasoned decision violates the petitioner's fundamental rights under Article 1421 of our Constitution. Whether the imposition of 1 lakh has caused on a bona fide pill petitioner in the absence of any finding of malafide, a political motive or abuse of process amounts to an arbitrary and unconstitutional exercise of jurisdiction. Whether the Election Commission of India refusal to disclose voter turnout in machine-readable format and destruction of CCTV footage within 45 days citing privacy grounds violates the citizen right to information and democratic participation in the Constitution. Whether the Honorable High Court erred in relying upon the decision of the High Court of Kamal Nath without considering the subsequent constitutional and statutory developments, including 2003 Constitutional Bench on the appointment of Chief Election Commissioner, which has been totally diluted in favor of the executive by the second respondent, the Government of India, raises serious concerns of independence. Whether the High Court failure to consider binding or persuasive precedents from other High Courts and this Honorable Apex Court in Bihar, SIR, social, all that. Then, more important is the grounds. Grounds, you are giving evidence, no, that will be facts. First ground, because the Honorable Chief Justice of Madras High Court displayed disinclination to hear the matter from the outset, even threatening to impose costs in the preliminary stage itself. When the judge says, I will impose costs, then what will you argue? Today, Honorable Chief Justice of India said, you have to be humble, humane. After all, lawyer is also bar and bench are the two wheels of the justice administration system. And he cited many examples of how judges are very, very, going out. But in this case, lordships must have felt he has no case. He's got his right. We cannot say all that. Despite the filing of a detailed and well-researched bill supported by expert materials, the petition was dismissed with sweeping observation that it was based on political statements. Political statements, no. It is a statement made by a leader of opposition with evidence, research. Whole nation is talking about it. And no research was done. The Honorable Bench never went through it. Branding as misconceived. The denial of opportunity to present the arguments and evidence violates Article 14 and Article 21 of the Constitution. This is page 1 to 6. That's the order. This is the judgments which supports my case, Supreme Court judgments. Kripak was Union of India. Mohinder Gill was as Chief Election Commissioner. Fairness is integral to the election adjudication. State here, Uttaranchal, this thing, bona fide of pill must be encouraged. Bona fide pills must be encouraged. Because the Honorable Chief Justice concluded that no research was done while dismissing the petition by threatening of imposing costs at the outset and failed to appreciate the substantive evidence annexed in 20 video links with summaries, articles, and interviews of former CECs, retired SC judges, and constitutional scholars, along with report in the Hindu, the Wire, Hindu and Wire, you please read. Of course, somebody don't like because they think, because I find many of my students were scared. They were saying that, sir, everybody feels the government is winning because of vote rigging. But because they are BJP side. And I am not against BJP or for Congress and all. And we are a interested nation. Excerpts from Constitutional Assembly debates on electoral transparency, binding precedents of Apex Code. The impugned order, therefore, is manifestly arbitrary, substantively unreasonable, and a non-speaking order violates the judicial duty to provide reasons. That is also explained. Precedents. Because despite no allegation of malice, political motive, or abuse of process being made against the petition, the Honorable High Court imposed a punitive. The bill raised constitutional concerns supported by credible material imposed disproportionate unexplained cost violates Article 14, chills the exercise of 1918, deterring honest civic participation in the democratic process. The precedents we have given, Raj Narayan and all that. Because the Honorable High Court failed to consider the Patna High Court judgment in social, Honorable Supreme Court, here also if you see, Election Commission first said, we have every power, we will deny. Whatever we can do, nobody can question. But Justice Suryakant's beautifully, very mild, carefully handled and told them to do all these things. Actually, what Lordships said to do is what this Election Commission should have done. That's the matter. Then because reliance placed on Kamal is in favor of me. Because the Supreme Court believed the Election Commission is unbiased, independent, doing an excellent job, so we should not interfere with that. And Puttaswamy case is different. 723 pages judgment was there. And then ECI's coercive conduct says that such notices to Rahul Gandhi threatening penal consequence. See, every man is saying, why Rahul Gandhi has not filed it? Why should he file? Why should he file? But that's only because of somebody wants to protect their arguments. There is no need. Why should anybody file? And you say that if it is wrong, we will file the FIR. Secondly, CSDS FIR against scholar later stayed with the Honorable Court with commendation of his integrity. Why do you file that just like that? Is that the duty of these people? And why you didn't do for Union Minister? Until date, we don't know what is the problem that CSDS said. What is the way it is clear and all. No, nobody knows. It is possible they would have been threatened also. And last one, this was the basic. Seventh is the ground. But of course, this is not was the subject matter of the bill. But then court need not go by, because court is not really be concerned about setting aside the order of division bench. But now the court has to go through what I have said. The perfunctory manner in which he is dismissed serious allegations such as voter deletions and manipulation linked to external influence without providing information sought by Karnataka CS. This is a very serious matter. And therefore, we have filed this main prayer. And then now in the next, we will discuss about the documents that we have researched. You can see a very beautiful research. After analyzing everybody's thing, we have presented it. And this is objectives and reasons and all that. That appointment of CC, removal of giving him too much protection, all those things which are, you see, what is because this FIR, summary of the views and opinions of juries and pharmacies, everything I have explained. If you can see, we'll read it one by one. So at this video, I don't want to say everything, constitutional safeguards and independence, judicial, quasi-judicial functions, concern on executive interference and the need for collegiate and calls for structural reforms, lack of transparency and secrecy in the process, executive dominance leading to potential bias, short and inadequate tenure of commissioners, absence of collegium or appointment committee, and explanation of constitutional exploitation of the constitutional silence. All that we have taken. This is the judgment. We'll take up this issue later. Next, third part will be that. And so, dear friends, this is the second point we have completed. And the third will be coming into this thing.